Hello, I'm Sue O'Connell. Welcome. Today we got a lesson in why throwing elbows isn't necessarily the best way to get ahead in politics. Consider the case of Corey Lewandowski, the ex-campaign manager for Donald Trump. This video shows the moment when Lewandowski stiff-armed a reporter after a Trump rally. At first, Trump was a stand-up boss defending him, but today he kicked Lewandowski to the curb. Ahead, I'll get reaction from a top Democrat in the swing state of New Hampshire, so stay tuned. But tonight's top story is from the courts of law, where a battle over assault weapons is raging on two fronts. A judge in Connecticut is weighing whether a gun maker can be sued by victims of gun violence. The gun manufacturer is Remington, maker of one version of the AR-15 style assault rifle. The victims are surviving families from the Sandy Hook Elementary School shooting, which took the lives of 26 students and educators. At issue is whether Remington misrepresented a military weapon as being safe for use by the public. The attorney for the parents told the court an AR-15 is to a firearm what a tank is to a car. He added this.
How many massacres until somebody says it's just not worth it anymore? Until the people who profit from these assault weapons just say, you know, the profit is great, but it's just not worth it. But how many more Newtowns, how many more San Bernardinos, how many more Auroras, and how many more Orlandos, and probably in 6 months we can add another name to the list until the Remingtons of the world say, you know what, it just isn't worth it anymore.
My guest is the fabulous and wonderful Michael Coyne, the NECN legal analyst, and he's the dean over at the Massachusetts School of Law. Welcome to you, looking dapper as usual.
Thanks, Sue.
All right, explain this to us. You know, I know that the constitutional right of the right to bear arms makes this all different, but what's different from suing an auto manufacturer or any other device that you feel has been represented wrongly to the customers?
It's the federal act that's in question here. In 2005, Congress passed an act pushed by the gun manufacturers that in essence allows them to escape liability to third persons with respect to damages that they might incur as a result of being assaulted by these assault rifles and the like.
So if someone, if I bought a rifle and it misfired, that was the mistake of the manufacturer. I did everything right. It misfired and hurt someone. Basically, what the law says is that person I hurt can't sue the manufacturer, but could I?
Actually, that scenario, you both might have a claim. If it's a design defect, under the Act, that is not excused from liability. So you would have a claim, as would potentially the person, but if you were intentionally shooting at that person and injured them, or even missed them but scared them, there is no liability by the gun manufacturers to that third person. That's what the Federal Act has protected. And that's the real problem here, because like the cigarette manufacturers before them, like other bad product companies, what we're trying to do now is say, listen, economically it may make sense for you to continue to try to sell these weapons, but these weapons are weapons of mass destruction, and we're going to try and attach liability on the basis that you knew or should have known that they would be used with a high probability and risk of death, as is occurring in far too many times.
What is the difference between trying to come up with a court case where the owners, I mean, could the owners sue and say, listen, I bought this, someone told me it was a varmint rifle, it turns out it's an assault weapon, I want to sue the manufacturer for that?
See, I don't think so, because I think the person who's buying it knows that it's a high caliber, high ability to use with some level of frequency rifle. They're buying it precisely for that purpose. Those that are defending the AR-15 say that it is necessary. It is unfortunately far too common in existence in ownership in the United States, and that's the case that the Supreme Court took a look at, is Connecticut and New York's ability to try and control these rifles. And states do have some ability regardless of that federal act, but what we found in that case when you looked at it is the court said that it does still fall within the Second Amendment, although the state can restrict to some extent access to it, but what we have to recognize is that that gun, that rifle, is in large supply in households in the United States. and in states other than Connecticut and New York, it's protected.
Are we going to get down to a definition of what is in some ways? You know, there's been lots of, and there should be discussion about exactly what type of rifle this is. Is it an assault weapon? Is it a semi-automatic? Is that going to be where this argument goes?
When the Second Circuit looked at this case, what they did is really take a look at how, to what extent this gun is in use, how common is it the type of weapon that, in essence, the founders thought should be protected under the Second Amendment, like a revolver, like a pistol. And they found, while it's different, it is at least at present, in that case, insufficient supply that it should fall within the protections of the Second Amendment. I do think at some point, and I think that's what we're seeing in the state cases now with respect to civil liability, is the question of, did they know or should they know that this is a highly dangerous product and the people who are purchasing it are likely to inflict damage on third persons? If they can establish that claim and show that the gun manufacturers had some knowledge that this was more likely used as a weapon of mass destruction as opposed to self-protection and hunting, then maybe they can finally make that leap and establish liability of the gun manufacturers.
Well, let's look at yet another gun controversy that reached all the way to the U.S. Supreme Court today, and it happened on the same day that the U.S. Senate allowed for votes on several gun control measures. NBC's Steve Handelman reports.
The Senate will come to order.
The Senate gun debate was passionate.
American people don't feel safe.
But passing new gun laws looked unlikely.
Well, the Democratic alternative would not ensure due process.
Democrats back ending private gun sales without background checks and no-fly, no-buy, banning gun sales to anyone on no-fly or terror watch lists. Republicans demand a hearing in 3 days or any sale goes through.
Oh my God, people are getting shot.
In Orlando, the killer, Omar Mateen, had been taken off the watch list before he bought his Sig Sauer assault weapon. Breaking with most in his party, Donald Trump said he could back no-fly, no-buy.
Well, I think the message is if the no-fly list was really a rock-solid, high-quality list, then nobody wants bad people to get guns, right?
Trump said Friday good people at the club should have had guns.
Strapped right here, right to their waist or right to their ankle, and goes boom, boom. You know what? That would have been a beautiful, beautiful sight, folks.
But guns are banned in Florida bars. Trump today claimed he was obviously talking about additional guards. Assuming a loss in the Senate, Vice President Biden kicked off a new White House push
to ban AR-15 type weapons from civilian ownership.
Sale of all new assault rifles resumed in 2004 after a 10-year ban. But outlawing those sales is apparently constitutional. The U.S. Supreme Court today let stand sales bans on assault weapons in Connecticut and in New York. I'm Steve Handelsman, NBC News, Capitol Hill.
So this is a complicated issue because we're talking about the Constitution, individual states' rights, and whether or not states can ban whatever they want when it comes to weapons. What's your take on that?
Well, the Second Circuit Court of Appeals decision actually is quite extensive and thorough with respect to their analysis. And it comes down to this, if you think about it. The Second Amendment gives us the right to carry guns, to have an armed militia. But as the Second Circuit said, that right is not unlimited. So whatever type of handgun or gun you want, for whatever purpose and whatever means you choose to carry it, that the courts do not allow that. They are capable, the states are capable of restricting the use of that. That's what Connecticut and New York has done for these weapons. And they've said that in order to preserve public safety, in order to protect people, things that we expect our states to do for us, they do have the right as long as it's related to a legitimate state purpose.
So it's not a blank check. Actually, I think there's only like one amendment that has not been ever challenged in the Constitution for the most part. None of them are blank checks.
That's exactly right, and that's just what the court said, and that's what the Supreme Court said today by leaving it alone, is that none of our rights are unrestricted. The state has the ability to restrict it. I hope and I think that this is likely to be the first step, as we see now in a number of years, where the states actually look to ban or at least to limit access to these rifles because of all the mass shootings that we've had and the incredible risk to public safety. And that's what New York and Connecticut have recognized.
On a political standpoint, standpoint, it has been fascinating to watch Republicans suddenly concerned that there was no right to due process on the no-fly list. We've had this no-fly list, I'm not even sure how long as I can remember since 9/11. Not once has a Republican said there's no right to due process on it until like this year.
We all use the law for our own purposes at times, and I think that's what we're seeing here.
Great. Michael Coyne, thank you so
Thanks,
much for
Sue.
coming in. Good to see you
Always
as
fun.
always. Take care. All right. My thanks to Michael Coyne from the Mass Lawyer School there. Whatever it's called, yeah. And here's one more voice on the question of assault weapons. Senator Elizabeth Warren wants to ban weapons she calls Rambo style. She delivered these remarks from the Senate floor.
We can ban Rambo-style assault weapons. We can take these weapons of war off our streets. We can also close the terror gap. The FBI should have the authority to block gun sales to anyone they believe is a terrorist. If someone cannot get on an airplane because the FBI is concerned they might be plotting to do harm against Americans, then they shouldn't be able to walk into a store and buy a Rambo-style assault weapon. We can keep weapons out of those who would do us harm. We can make it harder for terrorism to take root in this country. We can drive the forces of hate out of our nation. We can build a stronger, more united America. And we can begin right here in the United States Senate. We can begin right now.
Next, a guest from the purple state of New Hampshire, where the governor's a Democrat and the House and Senate are controlled by Republicans. A swing state, if ever there was.